So this is the reprise on a session called Is Genetic Privacy Threatened? The last group was treated to more structured presentations, and this group is going to have more discussion both among the panelists and with you, the audience. We have as panelists, by the way, I'm Bill Sage from the University of Texas at Austin. I do very little work in genetics, but I work with Deborah on a lot of things, and she conscripted me to host these sessions. But we have very expert panelists, so from my immediate right to my far right, we have Ann Cook from the University of Montana, who runs a Center for Rural Bioethics there. We have Laura Rodriguez, who is the director of the Office of Policy,
Communications and Education.
Communication and Education at the National Human Genomes Research Institute, which is part of National Institutes of Health. Then we have Jeremy Gruber, who's president of the Council for Responsible Genetics. Then we have Ed Abrams from the Personalized Medicine Coalition, and on my far right, Kathryn Serkes, who represents and founded the Doctor-Patient Medical Association. We heard a lot of presentations in the last hour on issues ranging from the existing structured regulation of the collection and use of genetic information, so that's the Genetic Information Non-Discrimination Act at the federal level and a host of state laws, on through some serious discussion of different research considerations, both what's happening broadly in the community and then which tends to be commercially sponsored clinical research protocols, to what's happening with direct NIH sponsorship, which tends to be more on the basic science of human genetics, looking at the long-term implications for health. We had some conversation about the ultimate applications to personalized medicine, though perhaps we should talk a little bit more about that this hour. And then we had a lot of discussion, mainly really in each of the presentations, that was about genetics, but I'd probably say not so much about health or health care. So I'd probably kind of start it there as a question. We all have this sense of genetic exceptionalism, or genetics is different. Someone even sort of interpret the genetic privacy threatened as the title here. Someone just thought, well, it said, is genetic privacy different? Because we're very used to seeing that title. Is genetics different? Is genetics privacy different? Let me ask a version of that isn't just the is it different, but what are the differences you see between thinking of genetic privacy in this session and thinking of health or healthcare privacy and everything else we've heard at this conference? What are ways in which genetic privacy doesn't exactly match up with our notions of healthcare privacy? Jeremy, why don't you start, because you had some things on your slides that
well, I mean, I think just as was mentioned in the last hour, that the robustness with the type of information that we can learn from DNA, that it's simply not limited to health-related information, that it can reveal things like ancestry, paternity, and identity. We talk a lot of times, we talk about privacy with regards to biobanks and other areas, but there's a whole other area of privacy concerns with regards to DNA use for identity purposes by law enforcement, and the databases that are being created with regards to that as well. So I think the variety of uses that go beyond health information, I think, is one area that makes it that makes DNA and genetics a little different. And simply by the amount of data that we're creating, we have a focus of biological research in this country right now that is on genetics, and the amount of data that we're creating around genetics is increasing by the second. So simply the concerns around big data and around research and clinical care and the amount of information that's being created is one area as well that I think we're talking about.
Kathryn, what does it look like for you? Is she there?
No, Kathryn's MIA.
Oh,
she did leave her
glasses. That's the problem with very long panels. can't see
No,
who's down at the end. I'm like,
but you were right to call on her.
thank you. Well, and, okay, what would Kathryn say? No, why don't you talk about it in terms of sort of this personalized medicine? One of the things that I think this blends into for me is whether, so there's this notion of privacy around genetics, but there's also this notion of opportunity and interest and kind of opening new horizons, and some of those come from, the big entities in our society, but a lot of them seem to be quite personal. So what do you think about these differences between genetics and other issues?
Well, the question, is genetic information different, was one of the reasons it took 12 years to pass the Genetic Information Non-Discrimination Act, because the opponents of the bill said that it is not different. It's just information or data, and we have laws in place to deal with it. Through the work of Francis Collins and many other proponents of the bill, including the Personalized Medicine Coalition, the law was enacted because it did recognize that, at least in the public perception, genetics was different. I do fear that we put too much emphasis on genetics as determinative and different in the public mind, and that makes some of these conversations we have more difficult than they should be, and then we lose sight of what I think of as the promise of personalized medicine, which can be delivered through aggregating lots of genetic information and understanding how people are different and developing treatments that are going to be targeted to those people based on those genetic but also other kinds of differences, including proteomic, metabolomic, phenotypic differences. We can do a lot with new technologies, including computer technologies, that we couldn't do before, and that open new horizons in medicine, and I think that everybody in this room applauds. So we have to figure out how to negotiate some of the issues that concern people about privacy and other issues.
So, Kathryn, the question is genetic privacy, health privacy. One a subset of the other, close overlap, broad non-overlap? How do you think about the two from your perspective?
I think that what I just heard you say is that you think that there's too much emphasis being put on genetic information as being some other class of information as opposed to the other information in the medical record, and that's what makes patients cringe when they hear you say that exactly that type of statement, because whether you agree with them or not, from your perspective, they do see that as different.
I understand that.
And they see that this is a personal property issue, and that it's deeply personal. I know that we have a raging debate on the medical record. Traditionally, for those of you who aren't clinicians, traditionally the position with going to paper records was that the patient owned the information, the doctor owned the piece of paper. That's been how that's worked. The doctor owned the piece of paper. Therefore, if the patient wanted their information, you'd make another copy because the patient was entitled to the information in that record. But we've moved into a new era where the insurance companies also claim ownership of the information. So when we translate anything that goes into that medical record, then the insurance companies also own. They claim ownership. And so it's somewhat, I think that just even the idea of this ownership is offensive to the public. Do we have any more lay people here, or are you all geneticists too?
Well, I think the implication of ownership is very frightening to the public.
Yeah.
I think it's very frightening. And it was, when we've been doing our studies of patient decision making, as I said in the earlier discussion, their earlier session, most patients had very, very little understanding that when they were participating in a research study, and when as part of the research study they were, having blood samples taken every week or something, that involved in any way genetic testing. The other things that they really did not understand was why research was conducted. So most of the people we interviewed, most of the research participants we interviewed, believed research was conducted for these very global, good of mankind, good of society, and they would cite things like, I remember when we stood in line and got the polio vaccine. So that was
Correct.
the idea of research. So as we're going along on our interview kind of template, we asked them at some point, would you want to know if a study you were involved in had a commercial purpose, like developing a Me Too drug or extending a patent? Because one of the things we found out is that the vast majority of studies that are being conducted in clinician offices do have commercial purposes. As a matter of fact, most clinicians have told us that they can't afford to take federal studies because the reimbursement is low. They take industry studies. And so we asked patients, would you want to know that information? Most patients were absolutely shocked. They said, we had no idea that our doctor, that our hospital would conduct that kind of a study. And then they would say things like, I would never want to be involved in that kind of a study because our family can't afford medication, or I can't afford my heart medication, or I can't afford this. I would never want to be in that kind of a study.
What's the connection there?
And
I'm not sure I'm understanding.
So the connection is that
I get it.
they don't understand that they are in studies that, first of all, have commercial purposes, and they do not understand that they have studies that involve collecting their genetic samples. And when they do understand those kinds of issues, then when we ask them, would you want to be involved in a study again, they say, probably not. I'm not sure I would. I don't know if I could, only if they promise to give me information. So I think that this idea of ownership and what's happening to the information and what you're really doing and what's being collected is very troubling for patients because they don't understand this kind of fluid genetic map that's being made, and they don't understand how their information is going to be used, and they feel that they're at risk of being victimized because of that.
I would suggest that there is an inherent difference as well,
Yes,
because
there is.
because of the unknown.
The unknown.
And that's what we're saying is that we're going to, on two levels. Number one, we're going to take this material, genetic material, from you, and number one, we're not sure how we're going to use it, and what we're asking for is permission to use it
20 years down the road.
down the road. But also, we don't know what information may actually be identified. That's what I was talking about earlier, is this issue of, we know what we can get out of it right now, you know, and to the rest of us, that's very frightening because we can barely understand what you can get out of it now. Right. And you're telling us that we've only begun to tap what kind of information that may be useful down the road out of this information, and that's very frightening. It's a little bit different, manageable to understand that if my medical record says that I have diabetes, I can kind of assess the threats and dangers about that information being public to my employer or to other people. It's a little bit easier to understand right now for people. So then not only is it we don't know what we're going to do with the information, but we don't know what this information may look like that we are going to be sharing. So I would say that does make it different.
And we don't really know if it's for the good of mankind or not. It might be for other kind of purposes. And so people are very, very confused.
Before I go to David, let me ask Laura actually to comment a little on, so we've morphed into a discussion of research that has a lot to do with kind of the motivation and trustworthiness of the research, and specifically with the long time horizons and the storage, either in physical form or informationally, of genetic material. So there are, now, are the revisions to the common rule on this proposed or adopted at this point? I've lost track.
They're proposed.
That's what I thought.
Yeah,
so talk a little about that. And
proposed, or has there just been an
It's just the advance notice so far, so they're not,
well,
so they do not have draft rules on it.
no, it's just
Not
the
in
advance
rulemaking.
notice at this point, so.
There are no rules proposed.
Well, yeah, I mean,
There's a pre-draft rule.
yeah, functionally, I would argue they're proposed within the notice and comment informal rulemaking. They're not a proposed rule, but. Well, I've heard Francis Collins give a list of what the contents are. So I was just hoping you could kind of share with us with what the thinking is on because there's specific changes that are proposed.
So I guess I'll focus around, and again, federal government is a very big place, so NIH is participating in the drafting of the rule, or the proposed rule for changing the common rule, but they are not the keeper of the thinking in this, and that lies with the Office of Human Research Protections, which is the enforcer and the regulator in this domain. So I know that the thinking right now, and it was done in a combination of proposed rule and questions about that proposed rule. So the RFI was very mixed and hard to understand, I thought, what they were trying to do. So around the use of biospecimens, which is what many people are concerned about because it's the physical issue. It's what the case was that you mentioned before, where the university owned the biospecimens and didn't want to transfer it. So in that context, they're talking about how do you govern that future use, and is consent required? Should consent be required for everything? And I think that gets to what I was thinking as I listened to everyone around this ownership issue, and how much of the ownership issue is focused on the autonomy principle and the right for choice that participants may want, and that transparency need of knowing what's happening with the research and knowing what's happening with their information and getting some feedback. And there's some data really that they want to be asked, participants want to be asked. It's not that they may be opposed to it, but they want to be asked what's going to happen so that they also know what's happening. And all of this is on the grand scale could be considered anecdotal because we have small numbers that are going, and not it's whether or not it's representative. It's going into rural populations versus urban populations versus Native Americans and the different communities of people that you would want to talk to. So all of this is making me think about that there are lots of confounding issues that get conflated in what we're talking about. If you look at criminal DNA databases versus research biobanks and what the purposes are. They're very different. They're collected in different ways. They're governed by completely different things. But the fear about DNA criminal databases gets completely wrapped into what's going to happen with research and how is the privacy protected in research. And so I think that also comes back to the same thing that's at issue in the common rule and the ownership issue of as a society, what do we think appropriate uses of genomic research should be, and how do we govern that, and how is that the same or different than health information, and looking at that, because I think that would provide a way to filter through some of the concerns if you were looking at different uses of the information, because people may be supportive of health research, whereas they don't want anything that's for marketing or for insurance purposes or for criminal issues where it's a different situation. So other things in the common rule that can be at issue is this idea of identifiability. Currently, genetic information in and of itself is not identifiable. You can use it in any way that you'd like, and it's completely within the bounds of the law and of the ethics within which that law was structured. But the common rule seeks to now come back and say, okay, we know that we're looking at whole genome sequence information. We're not looking at one gene at a time. And so when you have that information, does that change the structure through which we should look at this? And so should we now consider biospecimens, because they contain genetic information, as inherently identifiable? And then also, should we require explicit consent for any research to be done on any collection of biospecimens, or by default genomic information? And by explicit consent, I don't mean specific consent. I just mean that a consent for research purposes was obtained, because right now a lot of research is done with excess clinical samples where there was never a consent for research purposes. And again, when the common rule was crafted, that was thought to be perfectly acceptable. And now with all of the information and all of the technology advances, people are beginning to rethink that itself. So.
You also, go ahead.
I think one of the things I'm hearing is that we don't trust the institutions with whom we were sharing genetic or other kinds of medical information, and therefore we're going to rely on, I would say, are questionable notions about ownership of data, because we don't trust these institutions. And I think if we continue to move along those lines, we will have serious problems in terms of advancing research to solve medical issues in the future, which would be regrettable when we're on the precipice of what Francis Collins has called a new era in medicine, based upon these new technologies that have become available to us. So I think we really truly do need to examine whether we can trust these institutions that are out there or not, in both the nonprofit research side as well as the commercial world. And if we do lose that trust, and it will seem to me be regrettable, and I'm hearing that we are in the process of doing it.
Well, I'll leave hanging the questions that it seems from a lot of this conversation to me that for the most part we don't pay attention, and when we do pay attention we don't really trust anyone except ourselves.
Yeah, right, exactly. So, I mean, so it's a question of self and society, and if you only trust yourself, well, you know, that's a very bad place for this country to be in, I think. And it extends beyond medicine, obviously.
I think it's important to illustrate through maybe some actual examples of some of the situations that I think we've been talking about. And I think two relatively good examples that I'd like to just discuss for a second. One is with newborn screening. How many of you have children? Most of us probably have had children. Did you know that when you went into the hospital and had your child and signed a form, that you were not only consenting for them to be typed for certain inherited abnormalities at birth, but that their actual blood spot sample would go into a biobank? How many of you knew that when you signed the forms? Most people don't. Most people aren't even aware of that at all. And
the question is what you do with that information.
No, I disagree.
No, it's not.
I disagree. I think that's a fundamental misunderstanding of what privacy means. Discrimination. You know, when we talk about discrimination, we talk about the misuse of genetic information, but the idea that your information can be taken and as long as it's not taken and used for certain reasons, that's okay, I think is fundamentally, for me at least, is fundamentally wrong. I think we have to make a decision as to who controls your information. Do you control your information? Do you have decision-making power over your information? Or does some other entity, and we have that decision-making power, and are we only going to institute legal mechanisms to prohibit certain uses of that information that we find particularly abhorrent, such as employment discrimination, health insurance discrimination under GINA. But the truth is that most people don't want to have their information used without knowing for what purpose and for being able to have some direction and control over it. And so I think and we've seen some perfect examples with newborn screening. We've had the unfortunate destruction of huge numbers of samples of newborn blood spots in Minnesota and Texas because the consent laws were deemed to be inadequate. The public was outraged, and the types of procedures that had been instituted that weren't improved because researchers didn't want to go to the trouble of improving those procedures. Well, that came back to haunt them because when the public did become aware, the public was angered. Another good example, I think, is a recent example that came from the direct-to-consumer genetic testing industry that's been mentioned. The largest direct-to-consumer genetic testing company probably is one called 23andMe. 23andMe recently received its first diagnostic method patent for a gene variant associated with Parkinson's disease. And one of the ways, the main ways that they had aggregated research towards identifying those gene associations was through individuals who had been participating through their sequencing services. And there was a huge outrage because people didn't realize that when they were using the services of the company to identify certain health-related information or ancestry or so forth, that it would be used to create a patent.
Yes,
and I think I think that is really sort of devolves into one of the larger issues that we talk about. Because when we're talking about who owns your information, well, the individual doesn't seem to own their information, but somehow all the laws seem to come together to support the commodification of that information and the sale of that information and the use of that information for products and services. And hopefully those are products and services that will benefit people. But somebody is benefiting financially, and it's certainly not the individual.
Do you think there's something wrong with benefiting financially?
Well, actually, I'm gonna stop you guys for a second and let's get a comment from the audience.
I just have a quick comment. Ownership, who owns the data or the information or the samples or what have you, should be spelled out in the consent form, correct? So maybe it's an 8-page consent form, they just went and signed it without really understanding what they signed.
So I think part of this comes, and this is probably way off topic, but I think it's fundamental to what we're doing, and some of this is, it just addresses the understanding level of between the public and, you know, these different sectors and what they're doing, and it's really hard to solve that problem, but it is something that we think about in general, about genomic literacy and understanding for individuals about, you know, what their genome is, what it means, what information it contains, what it can or cannot tell about it, and then that enables them to make the choices about how to use it in their healthcare, how to participate in research, and hopefully also deals with some of the fear. Because if they understand it more, hopefully there isn't as much fear around what might be done with it. It doesn't take away any of the obligations for transparency or having consent processes that are meaningful and trying to improve those processes, because they're not meaningful right now. And you know, again, how to solve that problem, I don't know, but.
David, you've had your hand up for a while.
Well, what we're talking about, to me, is fear of the public. And we already have a fairly good example of the public does not seem to fear public health reporting. I mean, there's a lot of mandated public health reporting, cancer, virus, communicable diseases, and nobody seems to have a problem with that. And obviously somebody does, but and the public is, I guess, become inured to that because it's been happening so long, and they think perhaps that's a good thing to do. I don't really know. I had a recent situation where I have a friend who had lung cancer, non-smoker lung cancer, and he had 4 to 6 months to live, and they found out he had a mutation, and they found out that another treatment was available for that particular mutation that was going to say was going to take about 4 to 5 years instead of 4 to 5 months. And that was done, I'm sure, that because there's a lot of information that people use, and I doubt that people would have any problem with that at all. I mean, I certainly wouldn't have any problem using my information to find out that solution. But it seems to me is we have a real difficult problem of educating the people, because I think if you explain some of this to them, if you go through it with them, but we've got this very fearful population that we may have created ourselves, and that's really our dilemma, because I think most people, if you give them those kind of examples, say, well, yeah, I'm fine with that. And we just have a real problem of people not trusting where the information is going and how it's going to be used. And I don't know how we solve that problem.
And the engagement to have that kind of conversation around what the examples
So we're talking cross purposes, and that's the issue.
I mean, I don't.
What cross purposes?
Well, we're fearful of losing our privacy and control over our lives for probably good reasons that are not medical at all, and we also want medical advancement. Your friend, I think, benefited from a new drug that was just developed in recent months, approved by FDA in recent months, based upon our understanding that there's 4% of the population that has a gene rearrangement that will respond to that drug. But that drug would not have been possible if we were not able to aggregate the data that showed that there are these correlates. And this is an example of medical progress, and I'm sure there's not a privacy advocate in the world that would oppose that.
And I think there's probably not 5% of people in the country who would oppose having their information used to discover.
But again, if they need to understand this.
There are many inconsistencies in the medical system, beginning with that we want Cadillac treatment, we want everything, and we want it to cost nothing. So
Absolutely.
the idea that we're at cross purposes isn't anything new in medicine or medical research. I want to go back to this issue of using the information for good versus evil, because it does matter on one hand, but it doesn't matter. In principle, it doesn't matter. We have if someone is a privacy advocate, the right to privacy is not dependent upon the use of that information. It's plain and simple. If someone is a constitutional privacy advocate, it really doesn't matter. And I'll give you an example. It's not about genetic information, but I was on a radio talk show, and the talk show host told me the story that she had gone into the hospital for an ultrasound when she was pregnant, and a little bit later, she received a gift basket from the hospital with various, baby things.
That's not illegal.
Diapers and things like that, and it was after she had miscarried. So the hospital was sending her a lovely gift. I'm sure they didn't intend any ill purpose for it, but that was a terrible episode for her. They used her information to do something she never expected to get gift baskets. She didn't sign a consent form for gifts or anything like that, and it never occurred to her that that's how it'd be used. And then the other thing, as far as the commoditization, I'm a huge free market capitalist, so I preface it with that. But I also do know people who have been very upset when they have found out that their genetic material that they gave because they thought they were doing something good for the good of society and participating in the study for the good of society for altruistic reasons were then used by a commercial company to make a lot of money on a patent.
Okay,
and that's,
so I get that, but let me interrupt because that wasn't the example that was given. Those examples are out there, and you may now be thinking of one, but that wasn't the example that was given. I understand that. What I'm having more trouble
you were talking,
with,
that's exactly what you were talking about.
That's your example, but it's not the last mention that's been made of the patent. The last mention that was made of the patent was in connection with 23andMe. So that's a company where people voluntarily paid money to get a service and got a cheap price for the service, but now it sounds like at least some of the people are upset because the company used the information and developed a patentable test.
So that goes back to the point of choice that Laura is making, in a way that people want to kind of know how things are being used and have the opportunity.
But I want to know where we draw the line. I mean, or where we make it, where we just say let's be reasonable, because a notion where you're contributing altruistically by donating, and then it turns out that someone you perceive to have had commercial motivation, that's sort of one position. Where you're engaged in a commercial transaction for a price and there's a use made that makes probably that price affordable to you is a different situation. The general tenor seems to be tell me everything, but of course when we tell people everything, they pay attention to almost none of it. So what do we do? What
it comes down to is I think that the big bugaboo is how do you do a good informed consent is what it comes down to, because I think people get it, they get it, but they didn't get it when they first went into Safeway and started swiping the Safeway card for their super prices, that was money that was going into a marketing database for people to crunch numbers, etc. When that first started, they just, Safeway's giving me a good deal. But now we get it, that we're trading off in these commercial transactions, that if I go to a website, I'm getting a good deal, that obviously it's something in it for them. However, as I explained earlier, I'm looking at those websites and I'm not finding it explained well. I just want to know as a consumer, I just want to know because it's a total opt-in, it's totally voluntary, I'm entering into a private contract, and that's fine. What we're talking about was the difference that you mentioned, which is you can start out with donating your tissue, your genetic information for something that, not that they deceived me, but it turns into something else down the road.
Right.
That information can turn into another study down the road that was not what I originally designed. Now, I understand that's difficult. What do? We go back and find every person that tissue came from 5 years ago and ask for a new consent. I understand that's unwieldy. But for public trust to be there, we have to come up with something that makes them feel safe. And what I'm suggesting is that if we work on the informed consent so that people really get it, that may happen, they won't feel deceived.
Okay, and I wasn't under the impression from what you said that yours was a temporal issue. You sort of described it more as people went to their doctor and they just made an assumption that if it's their doctor, it's research for the good of humanity, and it turned out it was commercial research.
That's true. And
What's the difference?
well, that's what's so interesting.
That's a good question.
That's what's so interesting in...
Drug companies make our drugs. The government doesn't make our drugs.
That's true. And that shows the depth of misunderstanding and the lack of understanding and and that's what makes all of this genetic stuff in a way so different. People don't know what they're consenting to. They don't know how information is used or for how long or by whom. And, I mean, they'll enter a study, they don't know, if it's going to a biobank or a biorepository, or if it's supported by the government or by a small company or by a group. It's just that it creates it kind of instills, when people then get a little more information, it instills a sense of distrust and worry. And I think that's in part what what we all don't want to do. We want society to maintain trust in the research enterprise. But when it is so fluid and when it is changing, people have a hard time knowing what they really did participate in.
So, I'm going to ask you, but as you talk, could you also address the fact that, coming back to the suggested revisions to the common rule, there's also a reclassification of the risk associated with.
Right.
And if you could talk about that as part of what you're planning to say, would be great.
Sure. So, and I guess I just wanted to respond here, because we've heard two different strains of talking about the research and the fact that the people that you spoke with don't know what's happening.
Right.
But I don't know, I'm not seeing that connected to what was in their informed consent form. And again, I think it's an understanding, and how are we accomplishing consent or not. And if you tell them everything, they don't listen to anything, because 8 pages is too much for anybody to take in.
That's what's required.
And right, to tell them everything.
That is what's required. You have to give them detail. You have to say things, or you don't get the consent you need. You're violating.
Right, so you have told
So
them.
how do you do that?
But the
problem is also who is telling them. Because again, it's not any different than the HIPAA privacy notices that you get when you go into your doctor's office and the secretary hands it to you. Somebody was telling me they always ask and explain this, and the person sits there and looks at them
They
like,
don't
I
have a
know
clue.
anything about it. And so who is the one? It's the doctor who is sitting there with the informed consent. I'm in pharma, so I know I write the consent forms. And we take it very seriously to say, what are we going to do? And we're very restricted at the moment under HIPAA on secondary research and what we can say, because you don't always know what's going to come out of the trial on a product that you might want to study.
Right.
Again, one of these genetic anomalies or something that really would help somebody. How do you explain that? Because you don't always know what it's going to be. But, it's then in the researchers, the person who has the contact, because I don't know who you are, and my company's not the one who's going to talk to you and tell you. How do you get them to explain it in a way so it is understandable? So I do think education is important. I think one of the other problems we're going to see is this whole big data. Talking about the Safeway example, you go into Safeway and you buy an OTC product for a disease. and then Safeway starts giving you other coupons based on that disease. They
Yep.
sell the information to Amazon or somebody, they aggregate it, and you start getting stuff about your disease or your illness. At the same time, you do something that's genetic, where you're doing research, where you're doing clinical trial information, and you're not sure how all of a sudden you're getting this marketing. And you may have a tendency to think it came from the pharmaceutical company that was doing your clinical test, where it usually would have nothing to do with that, because that is a very controlled place. It's the rest of data and the rest of the world that you're not thinking about that's putting together this data. It may not be your health record. It could be something else that you do that you're not even thinking about.
Well, the clinical
saying something.
Well, the clinical trial piece of pharma is well controlled, but there's a huge amount of informational transactions involving pharma that are far less well controlled. So you have no idea.
Yes and no. I mean, because I do think most of the pharmacists take privacy extremely seriously and are really looking to make sure they control that, because they don't want to be seen that way, but there are things outside of even their control. If you go out and you're looking at a website, if you go and you want to look at a book on a health topic, somebody's going to know about that.
So, and I think
The bottom line is that 8 pages of consent was written by lawyers.
Right, true.
And it's written by lawyers to avoid litigation and liability. It's not written to truly inform patients and give good and give information. It's written for legal purposes, not really for informational purposes. And that's not true. It's true of any of the consent.
Due to the law.
Yeah.
Of course.
That require you to
Yeah.
say things.
Yeah.
To say 5 pages of here's your right and here's what you
Yeah.
have.
So compliance with the law is not equal to true informed consent from a consumer perspective in many cases.
The goal is to try to make it as clear as possible, to really try to put it into words, and try to put medical terms into a 6th grade,
Yeah.
because I've done that.
Yeah.
And everybody tries.
It's hard.
For 7th grade understanding of terms, for the doctors up there that they would tell you are extremely complex.
Well, and you're trying to explain this to people who can't figure out how to punch the holes in their voter's ballot correctly, so it's not an easy task.
Well, so we're all acting or talking as if genetic risk is really, really, really scary. So, Laura, if you could finish and talk about how NIH and FDA and OHRP are proposing to classify genetic risks.
So I think that's the
That's
other
good.
part within the common rule is to acknowledge this this autonomy and choice with consent. But then also, because IRBs do get so wrapped up and others in all of the ills that could come of this information that can't be defined explicitly and that we can't quantify when we do define them exactly. And to say that to create a new category of risk associated with this so that it is informational and to put a bin and to try to have risk-based, I think throughout the common rule they're trying to do proposal, as it was written in the advance notice, was that they are trying to put some risk-based oversight into the system instead of as many binary switches as they had in the existing regulation, where it is or it isn't, and you get the full Monty with one and you get nothing with the other. And so trying to walk along the spectrum a little bit more. And so they have created this new informational risk, which is what would be required for the management of any genomics or biospecimen research. And that then involves IT solutions for data security. And trying to find the right standard for IT solutions. And that, again, I think is a big question of what will be the right standard and what trust do people have in those systems as well. And so, again, it also requires some level of understanding of what is informational risk. And I think from a public perspective, that's hard to digest.
It's tough.
Just
So.
as a side point, the common rule does not cover FDA.
No, I know.
No, I know, but
Oh.
I was asking what was, this thing was that would change, where they could change with FDA, and NIH does not cover FDA.
So, but FDA is clearly involved in the common rule part of it and has been involved in the advance notice development, even though they are maintaining their distinct authority and their distinct regulations. So.
Yeah, but FDA is what sweeps research within the common rule for the researchers.
So I'm not sure if that got to your question.
Yeah, no, that was good, because I think it's actually, I think one of the things I've learned from the 2 days is that genetic information privacy sort of goes hand in hand with the development of computational capacity in society. You know, a lot of the rest of the conference, we've taken areas that develop on their own, and now the privacy associated with the information is changed by the computational capacity. But genetics wouldn't exist as an endeavor without the increases in computational capacity. Other comments from the audience? One thing I'll tell you what, sort of at the oversimplification level, I've now, I think, added one more term I think should be banned from health policy. I've long believed and said that the term reimbursement has to go. Reimbursement has to go because it's just payment.
It's payment.
And every time we think about reimbursement, we lead ourselves astray. It classifies the traditional activity wrong, and it classifies the new activity wrong. So it's just payment. But you know what? I'm going to add to that now.
I will tweet that because our doctors will love it that you said that.
I'm going to add to it informed consent, which I think has to go. I think it's just information. I think it's just information, and we're just barking up the wrong tree to talk about informed consent anymore. So.
Well, and I think that does speak to what we've talked about, is have another system beyond that, and notions that are coming about now and that we're beginning to think about in the literature, and how you would begin to implement this on a broad scale. I don't know yet, but this concept of governance, which would try to ensure, again, the transparency and some engagement with the public, so that there was some other kind of check for the research going on in 20 years, so that when you provided information or provided your specimen in 2012, you were confident that there was a system in place that you could trust, even if you didn't know exactly what was going to happen, to guide the research as it went forward. Now, some of that you could argue was what what the regulations were supposed to do before, to make sure that things were only done in an ethical manner. But the regulations, again, I think governance is a layer that is envisioned to be more dynamic, which also is why it's hard to envision how it would be implemented across the board, because of the infrastructure that would be required and that reasonableness that has to come in.
Well, I think we could have a whole nother panel discussion on where IRBs should go in research regulation. I'd have a lot more to say because it's an area I do a fair amount of work in. But I hope this has been fun for the audience. It's been fun for us. And thank everybody.
Thank you.
Thank you.